This holiday season, please consider supporting the Cato Institute and specifically the Cato Daily Podcast. Visit cato.org/podcast sponsor to get started. If you support Cato with a donation of $1,000 or more, I'll gladly give you a shout out on the podcast, or you can designate another individual to receive that benefit and all the other benefits of being a Cato sponsor. That website again is cato.org/podcast sponsor. And thank you for your generosity. This is the Cato Daily Podcast for Saturday, December 14th, 2019. I'm Caleb Brown. State constitutions protect liberty. That's no surprise. But it's important for state judges to know that the U.S. Constitution needn't be consulted if the liberty interest is protected by a state constitution. Rick Esenberg is president and founder of the Wisconsin Institute for Law and Liberty. We spoke in October in Colorado Springs about the whys and hows of protecting liberty at the state level. I will get some of the details wrong here, but my friend and former colleague Anthony Comegna at the Cato Institute sort of educated me about Abram D Smith, who wrote an important opinion in a case declaring that a man who had been liberated from slavery and ended up in Wisconsin was, in fact, a resident of Wisconsin and was due all of the rights that people in Wisconsin are due. And the U.S. Supreme Court overturned that case, but this was a case where the state constitution protected a liberty, the liberty of being a free person, and the federal government not going along with it. So that's at least an important example in Wisconsin of a state constitution doing a job that the feds won't do.
Right. It's a great story. Joshua Glover was a runaway slave. He was apprehended by federal authorities. He was being held in the jail in Milwaukee. An abolitionist named Sherman Booth got on his horse and he rode through the streets of Milwaukee, hollering, "Free men, arise!" And they executed what the local newspaper called the writ of open sesame, and they busted Joshua Glover out of jail in Milwaukee. There was then the 19th century example of the OJ chase, but it was with carriages and horses, and they chased Joshua Glover through Waukesha County. He eventually got away, disappeared, and was never heard of again. So the prosecution was against Sherman Booth for conspiring to violate the Fugitive Slave Act. Now, it wasn't just the state constitution that Justice Smith relied on in this case. He went one step further, a step that we would all agree that he probably was not entitled to legally take, although he was sort of morally correct. And that was that he said, I am not bound by U.S. Supreme Court decisions that have held that the Fugitive Slave Act is constitutional. And therefore, a unanimous Wisconsin Supreme Court granted a writ of habeas corpus freeing Sherman Booth. The case was appealed to the United States Supreme Court. The infamous Justice Taney, who wrote Dred Scott, wrote the majority opinion and reversed the Wisconsin Supreme Court. To this day, the Wisconsin Supreme Court has never accepted the mandate of the United States Supreme Court. And one justice who wrote not a dissent, but a concurrence saying that he thought the Fugitive Slave Act was constitutional, then lost his bid for re-election. In the over 150-year history of the Wisconsin Supreme Court, only two justices who were ever first elected lost their bid for re-election. He was one, and the other was a justice who in 1966 voted to allow the Milwaukee Braves to move to Atlanta. So it's a high bar to be not reelected in Wisconsin to the court.
So when we think about state constitutions and what those things guarantee versus the baseline protections that the U.S. Constitution is supposed to afford us, how seriously do state courts take the provisions of state constitution?
Well, they don't take them seriously, but they can. So what we like to talk about is what are sometimes called cognate provisions, where both the state constitution and the federal constitution protect a particular right, the right to due process, right to free speech, freedom of religion. Many of the protections in our Bill of Rights had antecedents in pre-existing state or colonial constitutions. And for about 150 years, most individual rights litigation, and there wasn't as much as there is today, generally took place in state courts interpreting state constitutions. But then in the mid 20th century, when the United States Supreme Court began to incorporate provisions of the Federal Bill of Rights into the 14th Amendment and apply them against the states, the use of state constitutions as independent guarantors of liberty fell into disuse. And there was a famous, or at least famous to constitutional lawyers, article written by Justice William Brennan in 1977 in which he pointed out an indisputable but overlooked fact, and that is that state courts, while they have to follow, they have to respect the protection of liberty, which the United States Supreme Court has interpreted these constitutional provisions to provide. Right? They have to go at least as far as the U.S. Supreme Court has said. You use the term baseline, it's a good word. They can go further. Right? They can interpret these constitutional provisions to provide greater protection for individual freedom than the U.S. Supreme Court has interpreted their federal counterparts to provide, because that would not interfere, that would not violate the Supremacy Clause. It would not contradict our federal Constitution. It would only augment it.
So, where's the fertile ground for states? Your expertise is in Wisconsin. Where's the fertile ground for states to go about beginning to protect liberty more vigorously than the U.S. Supreme Court does?
Well, Justice Brennan wrote because he was disappointed with the failure of the Burger Court to continue the rights revolution that was started by Chief Justice Earl Warren. And so he wanted greater protection against racial discrimination, gender discrimination. He wanted greater protection for the rights of criminal defendants. And of course, that's something that state courts could do. But there's no reason that it would be limited to rights that are favored by political progressives. So this would be an opportunity, for example, federal courts have tended to completely abandon any type of protection for economic liberty or any limit on the power of state governments to favor one set of competitors over another, or to put up fences that keep people from working, such as occupational licensing laws. And it's really difficult to make state constitutional claims that protect that type of right, the right to earn a living. I've tried, and so far I've failed. But it is fertile ground. State courts could interpret state constitutional provisions to provide this protection, either through examination of some rights provision in a state constitution, or through interpretation of the limitations on the state's police power. And because remember, we know that Congress has enumerated powers. If you open up the federal Constitution, it says Congress can do 1, 2, 3, 4, 5, 6, 7. State constitutions tend not to be that way. It looks as if they have plenary power, but historically, what courts have said is that states have the police power, but the police power is not unlimited. Now, it's gotten to be unlimited in sort of a parallel to the federal court's abandonment of the protection of economic liberty. But I think economic liberty is an area where courts can provide greater protection. Religious freedom may be another one where our United States Supreme Court has interpreted the Free Exercise Clause of the United States Constitution to say that if a law is neutral and of general applicability, it's constitutional, even if it impairs a religious practice. Some state courts, Wisconsin Supreme Court is one of them, has said, no, that's not right. We don't follow the U.S. Supreme Court. We provide greater protection for religious freedom. We say that if a state law substantially impairs a religious practice, then it is subjected to strict scrutiny. That is, it can only stand if it is necessary to achieve a compelling state interest.
And there's no less oppressive way to enforce that,
That's right.
that claim.
That's right. And so this is something that state courts can do. It's not something that they have done. For the most part, they've tended to to move in lockstep with the federal interpretation of these cognate provisions, these provisions that address the same thing. Lawyers often don't make the claims. A lot of times when you read a state Supreme Court decision, it will not distinguish between which constitution it's interpreting. And Judge Jeffrey Sutton, ironically a federal judge, recently wrote a book called 51 Imperfect Solutions, where he says that state courts shouldn't do this. They should prioritize state claims. That is, if somebody makes a state claim, and he says lawyers should make them if they want to represent their clients, that the state court should address the state constitutional claim first. And if that resolves the case because the liberty claim is upheld, then there's no reason for them to interpret the federal constitution.
That makes sense.
It makes sense. And I think it particularly makes sense now in that we see a great deal of conversation, or we hear a great deal of conversation about federalism now because of our, the divisiveness of our politics and the polarization of the country. And a lot of people, Yuval Levin and others, have said, look, federalism is a way out of this problem, right? If we can't all agree on one thing, then maybe states can adopt different policies and serve as laboratories of democracy. And then maybe we'll reach a national consensus. Maybe we won't, but at least we'll have this safety valve of, having these dual sovereigns, and California can go its way and Texas can go its way. And mostly when people write about that, they're focusing on legislators and governors, but state courts can do this too. They can serve as laboratories of democracy. And not only can they adopt differing interpretations of these constitutional provisions, but they can engage in a dialogue with the federal courts in which, they can say, look, we're going to interpret our right to be free of unreasonable searches and seizures in this way, and let's see how that works out, and maybe it'll work out okay. This is the way in which we got the exclusionary rule to some extent, and that this was a provision that the idea that if you gathered evidence in an unconstitutional way, it couldn't be introduced at trial. This was something that was developed at state courts and then eventually adopted by the U.S. Supreme Court for the entire country.
So it's worth then for judges who are interested in protecting liberty, which they all should be.
They should.
It's interesting to note that a rule that can emerge from states can later be essentially adopted.
Right.
And that's a really important thing for state judges to appreciate.
Right. In much the same way as the case that we started with, the case of Abram versus Booth, technically the Wisconsin Supreme Court had no business disagreeing with the U.S. Supreme Court on the interpretation of the federal Fugitive Slave Act, but in a larger sense, they turned out to be correct. And so that dialogue that they entered into may have been part of the entire, the entire national conversation that led us to appreciate how wrong we were.
Rick Esenberg is founder, president, and general counsel at the Wisconsin Institute for Law and Liberty. We spoke in Colorado Springs in October. You too can become a Cato podcast sponsor. Visit cato.org/podcast sponsor to make a gift today. And thank you.